Mr. Willis.
Your Honours, today I'll make 3 submissions. I'll first submit briefly that Justice Carlos's characterisation of Mr. Reddington's injury was correct. Secondly, I'll then submit that His Honour erred in inferring from this injury that Mr. Reddington was able to work as a sales assistant. I will then submit in the alternative that even if Mr. Reddington could work as a sales assistant, he was incapable of working 4 hours a day in such a role. My learned colleague will further submit that if Mr. Reddington could work 4 hours a day as a sales assistant, he would not be able to earn the required 60% of his previous income. And then we'll then submit in the alternative that Mr. Reddington has no other reasonable prospect of obtaining work which would enable him to meet this threshold. We therefore submit that Mr. Reddington has impairment of bodily functions which would limit his earning capacity to beneath 60% of his prior injury earning capacity and therefore warrants the issue of a serious injury certificate. And before we begin, I'll quickly set out the relevant legislative provisions that are in issue in this case. Section 252A(c) are not in issue in this appeal. What is in issue is whether the trial judge should have been satisfied of Section 325(2)(e) and (g) of the Workplace Injury Rehabilitation and Compensation Act 2013, which require that an injury, when having regard to the prospects of suitable employment, results in a loss of earning capacity of up to 40% or more. Now, Your Honours, I'll now move to submission 1 on our written submission. And I'll just speak briefly on this because we do not intend to reopen the trial judge's finding of fact as to the nature of Mr. Reddington's disability, but I would just wish to re-notify this court that His Honour Justice Carlos found that Mr. Reddington was now a man with a significant physical disability. We'll reopen some findings of fact later in our submissions in regards to his choice of sales assistant as an appropriate employment. Now, as per the judgment of this court, in West Farmers and Lloyd, decided in the Victorian Court of Appeal in 2016, case number 41, and with your Honour's permission on myself and my junior, I will now dispense with formal citation.
Yes, Mr. Willis.
Unless there is a specific error relating to the factual conclusions, the court will not interfere unless it is plainly wrong. And we would further draw your Honour's eyes to judgments in Victorian Work Colour Authority and Kalenjuk, which states that while the court must conduct an examination of the evidence, they should have due regard to the trial judge's advantageous position as a trial judge. Now, in this case, we submit that it was open to the trial judge on the evidence, especially given the testimony of Dr. Jackson, who as an occupational health consultant is best placed to assess the impact of the injury of Mr. Reddington in regards to the workplace, that he had a serious physical disability. And so unless your Honours desire it, I will not speak further on this point.
No, that's fine, thank you.
I will now move on to point 2 of my submissions. And we submit that His Honour Justice Carlos erred in finding that Mr. Reddington was capable of working as a sales assistant. And firstly, we submit that Justice Carlos did not give adequate reasons for his finding. In the case of Murphy and Ford, it was stipulated at paragraph 97 that a failure to provide reasons amounts to an error of law. And while perfection is not required, the trial judge's reasons must enable the losing party to understand why they lost the case. Furthermore, in the case of Zhang and Joy Foods, it was established that we must be able to discern the trial judge's reasoning process to understand why they reached the conclusion that they did. And in this case, we have no reasons for why Justice Carlos concluded that a sales assistant was an appropriate job for Mr. Reddington. If I'll take you to the extract of the trial judge's judgment, the one which begins with, "I'll now deal with the more complex issue." Judge Carlos states that he considers the only suitable alternative employment option put forward to be that of a sales assistant. Now, Your Honours, there is no weighing up in Judge Carlos's mind as to why a sales assistant was the appropriate role. He has given no regard to how a sales assistant is perhaps appropriate to his disability when some of the other occupations were listed were not. He should have engaged in a reasoning process, weighing up the pros and cons before he reached the conclusion. In this case, from this extract, we have no evidence that he did do that, and so therefore we must infer that he did not, and pull this essentially. From this extract, it appears as if Judge Carlos has chosen the role of sales assistant out of thin air with giving no due regard to its considerations. Furthermore, while we know that Judge Carlos did consider his education and employment history briefly, there is no explanation of how this education and employment related to the choice of sales assistants. job.
Mr. Willis, can't it be said that the report of Dr. Nutbean supports the decision? Dr. Nutbean identifies a sales assistant role.
Your Honours, I don't believe it is stated in the extract that Dr. Nutbean did find that a sales assistant role, but it is stated in the vocational assessment that a sales assistant role was appropriate. But I would then point Your Honours to the case of Richter and Driscoll, which found that while a vocational assessment may be a good way of inferring possible options, it is up to the court to make the final conclusion based on the competing facts and issues raised by that case. And Judge Carlos didn't go through that reasoning process. And furthermore, while it was mentioned that in the vocational assessment that a sales assistant might be an appropriate job, Judge Carlos doesn't actually cite the vocational assessment. And so in this case, the court would be imputing a reasoning process to Judge Carlos. And we submit that if Judge Carlos engaged in that reasoning process, he should have made it clear by stating it explicitly in his reasons.
What do you say that Judge Carlos should have done in relation to analysing the physical restrictions and capabilities of the injured worker against the duties of a sales assistant?
So I would have we submit that Judge Carlos should have engaged in a finding of fact as to the precise limitations of Mr. Reddington's mobility, and then compared that to a job description of a typical sales assistant role, and compared those two and explained, if he concluded that way, why the significant physical disability that Mr. Reddington had did not translate to an inability to perform the role of a sales assistant. And so, in short, Your Honours, just to conclude this submission, we submit that with this lack of reasoning in Justice Carlos's assessment, in regards to the choice of sales assistant, we should regard his decision as affected by an error of law. And we would now submit reasons why the court should remake Justice Carlos's assessment and find that Mr. Reddington did have a loss of earning capacity. But if the court accepts no further submissions from our side, we would submit that at the very least you should remit the matter back to the county court for rehearing, given the lack of reasons. Apologies, Your Honour. We would further submit that Judge Carlos erred in applying a strict calculation of loss of earning capacity. As per section 3252E, as Mr. Reddington was a worker who was under the age of 26 when injured, the strict calculation to determine loss of earnings set out in section 3252F is not required in this case. On the contrary, we submit that as per section 3252G, a more generous test should be applied where the court must have regard to the capacity for suitable employment, but must only have regard to that employment. And we submit that this is a more generous test based on the context of that exception. And in section 325E, it is stated that this exception does not apply for workers who are under the age of 26 and also those listed in Schedule 2, Item 1. Those workers include apprentices, workers under the age of 21 and workers in a particularly vulnerable position. As such, it is important that the court apply a more generous assessment to determining loss of earning capacity.
Mr. Willis, do you have any case law that says this is in support or how this section works?
No, Your Honour, we do not have any case law, but I would merely point Your Honour's attention to the case of Project Blue Sky, which stipulated the correct approach to statutory construction is to situate the text within its context and purpose. And we submit that the context of that section of the statute stipulates that a more broader requirement be adopted. And so we submit that when Judge Carlos found Mr. Reddington could earn up to 60% as a sales assistant, he applied a strict application. We don't have this spelled out in his judgment, but I would ask the court to impute from his lack of reasoning that he found that as he could earn up to 60%, he could therefore not be issued a serious injury certificate, when in fact the capacity for suitable employment was only something that Judge Carlos should have had regard to. I will now move on to 2.2 of our written submissions. And we submit that a finding that Mr. Reddington could work as a sales assistant was glaringly improbable. And this was stipulated in Victorian Work Cover and Newen as a grounds for overturning a trial judge's decision. And Your Honours, while it is possible to conceive of a sales assistant role as one that is perhaps not as physical as a building or tradesperson role, we submit that nevertheless it would require significant amounts of standing and some degree of lifting.
Mr. Willis, I don't know Newen very well. Does that case specifically discuss the role of a sales assistant, or does it just
No.
findings
It is,
that are glaringly improbable?
yes, it does not discuss the role of sales assistant.
Thank you.
And we're applying it on the legal principle it's set out more than anything else. And so to return to my submissions, two doctors, two doctors in his vocational assessment found that he had a restricted range of movement in his lower back, and Dr. Moot specifically stated that he couldn't lift weights up to more than 5 kilograms. We submit that a sales assistant would regularly have to lift weights of up to more than 5 kilograms. While they are selling things, they're also expected to restock the matters that they have to sell.
But doesn't Dr. Moo say that that Mr. Reddington's catastrophising his symptoms?
I would point that Dr. Moo actually states that Mr. Reddington was catastrophising his symptoms, not catastrophising. I don't know what catastrophising means, but nevertheless,
Neither do I.
So we submit that the court should not read any reasons into that, as it is nonsensical. But later on, she does say that independent of his psychological assessment of his symptoms, he is capable of performing duties if he avoids lifting weights in excess of 5 kilograms. And so Dr. Moot does not specifically state that 5 kilogram limit is psychologically imputed into his idea of assessment.
So how much weight could the trial judge have given that report, given the inconsistency that you say?
Well, we submit that the trial judge should have given that report very little weight, but I would also point Your Honours to the fact that Dr. Jackson also found that Mr. Reddington had a limited lifting capacity. And as such, even if Dr. Moo's report is to be dismissed for inconsistency, we still submit that Mr. Reddington would be incapable of lifting amounts which would be expected of him as a sales assistant. No, Your Honours. And this goes to my earlier point in 2.1, which is that this was something that Judge Carlos should have gone through and considered the role of a sales assistant to find that. And so we submit that as a matter of common sense, a sales assistant would be required to do those jobs. If Your Honours do not find that, perhaps it would be best to remit it back to the County Court for rehearing. In the interest of time, Your Honour, I will not touch on 2.3. I'm content to rest on our written submissions for that point and will instead move to 2.4, which is that the trial judge erred in failing to account Mr. Reddington's limited education experience in finding that he could work in a sales assistant. And Your Honour, we would point Your Honour's attention to the case of Richter and Driscoll, albeit in a different context, that of weekly payments. It was held that suitability of work goes beyond mere physical capacity to do the tasks, but attaches to the putative worker's ability to be a reliable and consistent member of the workforce. Your Honour, Mr. Reddington has very limited experience in sales. He has only worked briefly at a supermarket part-time while he was completing his apprenticeship a number of years ago. That is the extent of his experience in sales. He has limited education such that he is unlikely to be able to learn the necessary skills quickly.
Is Uber work sales work?
I would say that we would submit that Uber work is not sales work, purely because there is essentially, by the time the Uber turns up at your doorstep, the sale is already been made. You do not have to convince the passenger to come into the car once you've arrived, or in most cases. And so, as such, given his limited experience and lack of education and a lack of evidence that Judge Carlos turned his mind to this matter, we would submit that a sales assistant role is inappropriate for Mr. Reddington, given his incapacity to adapt and also limited experience in that field. In the interest of time, Your Honours, I will not speak on 3.1 as it is an ancillary point. And so if Your Honours have any further questions, otherwise I will conclude my submissions.
Thank you, Mr. Wills.
Your Honours, I'll be submitting submissions 4 and 5 today. Submission 4 is a point in the alternative to submission 3, which my senior counsel has brought up briefly, which is, if Your Honours accept that sales assistant is something Mr. Reddington could do, we submit that even so, the sales assistant would not bring him over his 60% earning capacity requirement. Submission 5 is another submission that considers other suitable employment, and we submit that even with considering other suitable employment options, Mr. Reddington still cannot bring his earning back above 60% of the previous earning capacity. So first, to start off with submission 4, and submission 4.1 is a reference to something said in the case of Harris and DJD Earth Moving, listed there, which is saying, in considering what Mr. Reddington could earn, and I'm paraphrasing here, in considering what Mr. Reddington could earn, the court cannot consider the type of job in vacuum of other features. And we read this in line with cases like Richter and Driscoll, as well as section 3 of the definition section, defining suitable employment. And we argue that in considering how much Mr. Reddington could earn, characteristics like his age, his past experience, his education level, so on and so forth should be considered. And that was laid out in the medical evidence. And we submit, because of this, his honest finding that Mr. Reddington could in fact work 4 hours a day doesn't actually bring him above the 60% earning capacity. So I'm moving on to submission 4.2. And I'd like to refer to the General Retail Industry Award, because as a sales assistant, that is what Mr. Reddington's wages would be governed under. And we submit that the minimum weekly wages there, the minimum hourly wages would be $19.40 as a level 1 retail assistant under there. Of course, this is the minimum wages, but we submit to the court that there is no reason to believe that Mr. Reddington would earn above the minimum wages, given his education, his experience, and his age, so on and so forth. We submit that given this $19.40 minimum weekly wage that Mr. Reddington will most probably be earning if he does get a retail assistant job, this would add up to 20 hours a week, according to Justice Carlos's calculations.
Sorry, I'm going to interrupt. Are you putting it that the plaintiff won't ever see any wage growth into the future?
No, Your Honour, we're not.
Okay.
But we are submitting that any employment opportunity open to him now would not bring him anywhere close to the 60%. He may still be able to earn above 60% sometime in the future. However, no, we submit that he is far from earning that amount right now. Looking to a calculation, for example, relying on his $19.40 wage and 20 hours per week, which Justice Carlos accepted, that will bring him to $388 a week, which is 48.5% of his pre-injury wages, which we submit is far from the 60% threshold, and is evidence that it would take him quite an amount of time to actually reach the 60% if he can reach it in the future. We further submit that this calculation doesn't involve his need for breaks at his work. We submit that if he is working, the medical evidence provided by Dr. Nutbean, provided by the other experts, Dr. Moe, as well as Dr. Trevor Jackson, suggests that he does require regular breaks while he's working. If we factor in, for example, a 10-minute break every hour, that would reduce his working hours every day by half an hour. That would bring his wage weekly down to $340. Or if he takes 15 minutes break instead, it brings him down to $305, which is 38% of his pre-injury wage. And we submit that that is a very substantial decrease. And as Your Honour suggested, if he could earn up to 60%, it will take a substantial amount of time to get there, and that is not the test required in section 3252E subsection.
All right, how substantial? I'm hearing the word substantial a lot, but how substantial?
Your Honour, this would be a question for me to... I have not much evidence for this, and this would be a speculation, but we submit that as an indication, consider the maximum level, level 9 Retail Industry Award, level 9 employee under Retail Industry Award. He will still not be earning his 60%. So we submit that the big bar here to his earning 60% is his 20 hours a week limit, which was decided by Justice Carlos.
Are we permitted to take that into account on this appeal?
Sorry, Your Honour?
Are we permitted to take those awards, those figures into account on this appeal?
We submit that these figures are not precedent, they're not binding, Your Honours, but they are very powerful indications of what Mr. Rankin could consider. And it was actually a consideration in the case of Harrison DJD earth moving, and actually the Court of Appeal there criticised the trial judge for not considering any kind of pay rates, which we suggest is the same situation happening today, in which Justice Carlos is not obliged to look to the retail award, obliged to look at pay rates, but it's something he should have done in order to satisfy this whole criteria of actually reasoning through what he's thinking. Moving on to submission 5, actually, is to consider other suitable employment options. And we submit that Justice Carlos's decision on ruling out all the other vocational assessment options was actually correct. And we can reason through this in an intelligible way, as my senior counsel had brought up as the test earlier on, because we could look to things such as his physical disability, which we submit already rules out being a corporate security guard. Because if anything goes wrong, any altercation goes on, he cannot have the physical capacity to respond in a situation. We submit that a courier driver will be a problem for him. Even though he has displayed the ability to work Uber, courier driver means delivering goods. We have no guarantee that he doesn't have to deliver heavier goods, heavier items. As well as a courier driver might detail a more fixed kind of employment working hours, which is Mr. Rankin's prolonged amount of sitting, that's the problem. Whereas with Uber, he could take regular breaks. That's how that's distinguished from what a courier job is. The other jobs under there, surveyor, surveying assistant, health and safety inspector, building supervisor, we simply submit that Mr. Rankin has no past experience in those areas. He has low educational qualifications. It will be very difficult for him to seek retraining to be eligible for jobs like that. And we submit that Justice Carlos was correct in ruling those out. We like to point to the fact in 5.2 that Mr. Rankin has displayed in the past an ability to work 5 hours a day, but that was actually 5 days a week. We submit that this was viable for him because that allows him to work Monday, Wednesday, and Friday, which allows him to take a day off in between. That will be very beneficial. That will be very beneficial to his pain management because it allows him breaks, even though he is working more than 5 hours. So we submit to the court today that that is the biggest indication we have of the kind of hours that Mr. Reddington has shown the capacity to work for, which is hours that allow him to have a break 1 day in between each time.
What do you say we should make of the reference in the report to the pain management program in terms of an ongoing impairment to work? Couldn't it be said that his condition would improve as a result of that pain management program?
Your Honour, we submit that the pain management program was brought up by Dr. Moot. However, we submit that the pain management program simply allows him to deal with the pains, but doesn't actually help the injury itself. Bearing in mind the MRI scan does show what's colloquially known as a slip disc injury. This is not the kind of injury that certain sorts of pain management, like having painkillers and things, would help, because it is a skeletal damage. I'd quickly like to talk about the mention of Uber in the factual analysis, and as I have alluded to earlier, Uber, we submit, is actually a big indication of Mr. Reddington's inability to work long amounts of time. Looking at the facts around Uber, actually, we have no indication of how many hours it took for him to get that amount of wages, as well as it does indicate that if he does work Uber, that's what he can get. And we submit, therefore, the fact that he has worked Uber in the past it's not sufficient as evidence that he can work for longer hours.
Can I take you away from your written submissions and back to the Act just very briefly, if you've got a copy there, or someone does. If one looks at 325 2E1, it's clear that paragraph F is not to be taken into account when we deal with a worker under the age of 26. Now, as far as I can see, paragraph F is the paragraph that considers suitable employment. So that is, as I read it, not to be taken into account, suitable employment. And the question, does it not, comes back to a but-for analysis. What could they have earned but for this injury? Now, Mr. Reddington, I think, had taken some steps toward apprenticeships before he was injured. I'd like to know what the appellant says might have come of those but for his injury, because I can see that the trial judge made some comments about his failure to complete those apprenticeships.
Okay, Your Honour, I would try and unpack that question and let me know if I'm misunderstanding your question. So first of all, it's an interpretation point on section 325, E and F. And we submit that under section 325(2)G, the suitable employment is still a consideration, although it's not as strict a test as applied in F. And my understanding is Your Honour suggesting that because of this, it is open to Justice Carlos to run the but-for test to see what alternate employment could have earned him. Is that correct?
I'm just interested to know if you have any submissions on what might have come of the apprenticeships, if not for this injury that's occurred.
We submit that. So first of all, given the injury, the carpentry pre-apprenticeship would not have made a difference, because the work he could have found after that pre-apprenticeship would not be suitable for him anyway, given the nature of his injury. We submit that if he was not injured, he would be free to pursue these carpentry pre-apprenticeships and any other retraining he would seek. And that would be a consideration open to the court, but we are not given much information on how much he could earn or whether he could get a job as a carpenter. We're just given information that he did at one point commence a carpentry.
Yes, so if there was sufficient information on earnings, you're saying we could take that into account, what he could have earned in those sorts of roles.
Yes, Your Honour.
Thank you.
However, we submit that will only be relevant if there's evidence that shows he will earn more as a carpenter than he would currently. And again, we submit that this would probably not be the case. His earnings would probably be similar. Your Honour, I have run out of time for my submissions. I've allocated 12 minutes. May I have a 1 minute time extension?
Yes, certainly.
All right, thank you, Your Honour.
Interrupted you.
I'll just be finishing up my submissions under 5.3, which is that he had not unreasonably failed to participate in retraining. It's a lot of negative there, sorry, Your Honour. Basically, what we are saying is he has been reasonable in participating in retraining, and I am referring, of course, to his building and management diploma. We submit that it's irrelevant, as I mentioned, that he did not complete his carpentry pre-apprenticeship, because that would not have made a difference to his employability after he had completed it. And that concludes my submissions, Your Honour.
Thank you. Now it's Ms. Brown, I think. Thank you.
Your Honours, the task for Judge Carlos at trial was to determine whether Mr. Reddington met the statutory definition of serious injury in section 325 of the Workplace Injury Rehabilitation and Compensation Act, which I will now henceforth refer to as the Act. He could only give leave for Mr. Reddington to bring common law proceedings against our client, his employer, if he was satisfied on the balance of probabilities that his injury was a serious injury. And the onus to establish serious injury rested on Mr. Reddington. He was unable to satisfy the authority that he had a serious injury when he initially made his application under Section 328 of the Act. At trial, Mr. Reddington also failed to discharge this onus and persuade Judge Carlos that he met the loss of earnings threshold. So the question on this appeal is narrower than the issue at trial. It is, did Judge Carlos make an error of law in his determination that the plaintiff did not meet the economic loss criteria? So in my submissions, I'll outline the nature of the test that Judge Carlos needed to apply, and will show that he did in fact apply the test in section 325, subsection 2E2, and not the test that applied also to people over the age of 26. And I'll also outline how he evaluated Mr. Reddington's but-for injury earning capacity and his post-injury earning capacity. Using these determinations, I'll show that he's correctly applied the permanent financial loss test of 40%, and that Mr. Reddington's earning capacity as a sales assistant means that he will be able to make at least 60% of his but-for injury earning capacity. My learned colleague, Veronica, will address two submissions that focus primarily on Judge Carlos's written reasons and the issues that arise there in terms of adequacy and also his identification of sales assistant as a suitable employment option. So turning to my main submission, which is the second submission on our written submissions, and that is that Judge Carlos did not make an error in his application of the law. Rather, we would submit that he made an evaluative judgment, and that is a judgment that you might have made differently if perhaps you, Your Honours, yourselves were sitting on the county court, but we submit that it was still a judgment that was open to him to make. So turning to the nature of the test that was before Judge Carlos, the threshold test for economic loss that applies to Mr. Reddington as a man under 26 years old at the date of his injury is that the worker will, after the date of the decision or of the hearing, continue permanently to have a loss of earning capacity which will be productive of financial loss of 40% or more. Our learned friends were unable to give the court a case where this test has been applied. We would refer the court to the case of OGE and the Victorian Work Cover Authority, which is listed in 2.2 of our submissions. So this was a similar case where the man injured was under the age of 26 and he was also an apprentice. So they both applied to him. And the judge in that case, Judge Jordan, described the approach in comparison to the approach when the worker is over the age of 26 as a broad brush approach, as it's not a straightforward calculation and comparison of pre-injury and post-injury earnings, but rather it's a value judgment where the court needs to consider an alternate reality, if you like, where Mr. Reddington wasn't injured and he could continue on the trajectory that he was on at the time of his injury. So it was partly for this reason that Justice Brooking, in the case of Mobilio and Baliotis, described the decision on serious injury as a discretionary judgment or an akin to a discretionary judgment. He did so in the broader context of serious injury, but we would submit that where the plaintiff is under the age of 26, this is even more so the case. But clearly, we do submit that discretion can miscarry. So this court obviously has jurisdiction to find that Judge Carlos did err in his discretion in determining serious injury. But we would submit that if you look at how he has applied the test, that this hasn't occurred and that the finding was open on the evidence before him. So now I'd like to address how he did in fact apply the test. And I'm doing so just to emphasise again, not necessarily just in relation to his written reasons, which my learned colleague will address, but in how we can see how he came to his determination, his ultimate determination that he didn't meet the threshold. So first he would have determined the appellant's earning capacity without the injury. In determining what this earning capacity would have been, but for the injury, Judge Carlos came to the conclusion that Mr. Reddington had not shown capacity to increase his earnings beyond what he was earning at the time of the injury, $800 per week. And we can see that in the judgment because he does compare it with his pre-injury earning capacity. So he considers that the but-for earning capacity and the pre-injury earning capacity were the same. So while the relaxation of the test for under 26-year-olds is intended to account for the possibility that they may be in a developmental stage of their career, and that they may actually be earning significantly more in the future, the trial judge still considered that $800 per week reflected Mr. Reddington's earning capacity in the long term.
Do you say that the trial judge considered the issue of the apprenticeships correctly?
Yes, we submit that he did. So he took into account the whole matrix of factors and the individual circumstances of the plaintiff, and all the evidence before him to come to this determination of what his life and what his career prospects were at the time of the injury. And that took into account the apprenticeships that he'd started but didn't finish, the fact that it appears that he had a period of unemployment for about 5 years. If you look, he was working in the supermarket in year 11, but then was not employed with our client until 2014. He also has no qualifications apart from his year 10 diploma, and the trial judge particularly thought he lacked intelligence. So from all of this, we can see that he used this broad brush approach and considered the plaintiff's individual circumstances and character, which he assessed at trial, and as a judge with the benefit of being able to hear the evidence firsthand. His finding of Mr. Reddington's without injury earning capacity, we would submit again, does not have to be the only finding that was open to him. We acknowledge that he did not take a particularly positive view of Mr. Reddington's capacity for job growth, but we do submit that it was clearly a finding that was open to him and that was within his discretion to make. So I'll now look at how the trial judge determined the applicant's earning capacity post-injury. So here it's evident that Mr. Reddington has lost his capacity to work as a labourer or to do his pre-injury employment. But he does have a residual earning capacity, and you can see this from the alternative employment that he has undertaken since his injury, including working for over 6 weeks driving for Uber. So the task of Mr. Reddington at trial was to affirmatively prove that despite his residual earning capacity, he has lost 40% or more of his earning capacity, and that this loss will continue permanently.
Did the judge take into account the Uber work in his decision?
I would say that the judge did take the Uber work into account as evidence among the medical evidence as well, that Mr. Reddington did have capacity to work and came to the conclusion that he could work for 4 hours a day. So the appellants actually conceded in the junior counsel's submissions that while his current earning capacity on their calculations is below the 60% threshold, that it may not be permanent, and that actually in the not too distant future his earning capacity may exceed that threshold. And we would submit that that doesn't actually meet the test that is in section 325, subsection 2E2, which is that the worker will continue permanently to have this loss of earning capacity.
Ms. Brown, I noticed that the trial judge has said that the man did not complete his apprenticeships. He did not complete either of them, nor did he commence them. As I understand, he had at least enrolled in the carpentry pre-apprenticeship immediately before this injury.
Yeah, so he had enrolled in the carpentry pre-apprenticeship, but he hadn't commenced it yet. He attempted to commence it after he was injured, when he was at home.
Did the trial judge adequately consider the possibility that if not for this injury, he would have started that carpentry apprenticeship and completed it?
We consider that he did, considering that the trial judge also had before him evidence that Mr. Reddington had similarly completed an electrical pre-apprenticeship, but then had been unable to secure an apprentice. He'd completed a pre-apprenticeship but had been unable to start an apprenticeship, and also that he had had this long period of being out of work, which did indicate perhaps that, there's always the possibility that Mr. Reddington was about to change his life, but I think it's very fair for the judge on the balance of probabilities to find that that probably was not the case. And indeed, Mr. Reddington did have the onus to affirmatively prove that his but-for injury earning capacity, would taking into account the his career trajectory at the time was high enough that when compared with his post-injury earning capacity, permanently he will have that loss of 40% or more.
So you're saying the trial judge took a dim view of his track record and he was entitled to do so?
Yes, we would agree with that submission. So I would like to do the calculations for you. The trial judge held that Mr. Reddington's earning capacity, but for his injury, was approximately $800 per week. So this is the same as his pre-injury earning capacity. And he held that he could work for at least 4 hours a day. So the general retail award for a sales assistant, which I'd like my solicitor to please tender to the court, states that as a casual employee, and we do note that this is where our submissions differ from our learned friends.
Well, we'll need to mark this as Exhibit A. Thank you.
Is $24.30 per hour, and this amount per hour for 4 hours over 5 days comes to a gross weekly pay of $486. And this is above 60% of $800. Admittedly, it is only $6 above, but it does meet the threshold of 60% or more. And we would emphasise that it's a minimum, not factoring any penalty rates for hours that he may work in the evenings or on weekends.
Can I ask whether this court has the discretion to consider the introduction of new evidence that wasn't tendered in the court below?
We would submit that Judge Carlos, would have considered the
Judge Carlos
earning rates
just told me
for
that I do have the discretion, so we'll say yes.
Okay. Furthermore, we would urge your honours to accept this casual pay rate, as it is the standard way that sales assistants are employed, especially when they are at the age of Mr. Reddington. But we would further submit that even if you accept the appellant's calculations, that these only show that he has a current earning capacity that meets the threshold. And as I have outlined, it needs to be a permanent earning capacity that will not meet the threshold. And even if he had a current earning capacity that is below 60% of his pre-injury earning capacity, he would still need to affirmatively prove that this loss is permanent. And none of the medical evidence that he's been able to put forward has shown that his injury will not improve even slightly and take it above that threshold, even if it were currently to be somewhat
Ms. Brown,
slightly below.
Has the trial judge taken into account in your submission the medical evidence sufficiently?
We would submit that
adequately?
the trial judge did take into account the medical evidence. My learned friend will address this more specifically when she gives the court her submission on the adequacy of Judge Carlos's reasonings. But essentially, we say that the references, although brief, that he does make in his judgment do show that he has given a full consideration of the medical evidence.
And are brief reasons sufficient?
We would submit that they are, especially in the context of a short excerpt that we have been given. To sum up, Your Honours, we would submit that the trial judge did not err in his evaluation of the plaintiffs without injury and post-injury earning capacity, or in his application of the permanent financial loss test. Indeed, his judgment shows that he understood the statutory provisions and applied them faithfully to the facts of the case before him. What happened, rather, we would suggest, is that Mr. Reddington was unable to meet the threshold as he did not have sufficient evidence to discharge his onus of affirmatively proving the lost earning capacity. And my learned colleague now will address the written reasons given by Judge Carlos.
Thank you, Ms. Brown.
Your Honours, if I could first direct you to our fourth submission, that we submit that Judge Carlos gave adequate reasons for his determination. As both the cases Osmond and Harrison Earthsmoving stated, a judge must disclose a clear path of reasoning in their judgment. Your Honours, if I can take you to the excerpt provided of Justice Carlos's determination, just to outline that Judge Carlos fulfilled his obligation to provide an intelligible explanation that discloses the path of his reasoning. As you can see in the very beginning of the extract, Judge Carlos quite clearly states, and I quote, "Not one of the expert evidence presented suggests that Mr Reddington is able to return to his pre-injury employment." It can be implied from the making of that concession that Judge Carlos has had regard to all the medical evidence that has been tendered. He could not have come to this conclusion otherwise. So while it is brief, he has made mention of it, and so we do imply that he has considered it.
Should the judge specifically refer to that evidence?
Sorry, could you repeat the question?
Yes. As a trial judge writing the reasons, should the trial judge be specifically saying, I have taken into account the following medical reports, or do you say it's sufficient to simply say in a more general way that these are my findings based on the evidence?
So it's actually in the case of Jayata Lekhi and Toyota Motors that it was actually stated that it's not a trial by doctors' opinions, nor a trial in which relevant questions were to be decided on that footing. So in effect, medical opinions don't provide the answers to the Justice Carlos's findings. However, by stating that he has considered them, he's showing that his reasoning is logical and he has taken in account all of the evidence. If I could also point your attention to the next line, Judge Carlos also refers to the vocational assessment, and it's clear from that statement that he's also had regard to that evidence. So, Your Honours, we refer to the case of Harrison and Earth Moving. In this case, it was held on appeal that the trial judge failed to provide an adequate statement of reasons, and this was because the judge didn't mention any particular suitable employment for the applicant, and the judgment did not reveal an identifiable proof of analysis and reasoning, and that's the test for adequate reasons. In that case, Chief Justice Brooks and Justice Kavanagh held that the trial judge needed to identify at least one particular job which could be regarded as suitable employment. Unlike in Earth Moving, in this case, Judge Carlos has clearly referred to an alternative employment being sales assistant. We thus submit that the judgment is sound on this basis. So I reiterate, all that was necessary for Judge Carlos to determine was one form of suitable employment, and that's what the Honour has done. But for clarity's sake, I'll be referring to that in my next submission, and would just like to focus on the reasons in general for now.
So was it enough simply just to refer to one type of work and ignore the others?
Yes, so we take Earth Moving as authority for that.
Thank you.
So it's worth noting, in arriving at his conclusion, His Honour applied similar reasoning as in the case of Oge and Victorian work cover, having regard to Mr Reddington's motivation and referring to whether he had commenced his pre-apprenticeships and apprenticeships. Unlike in the Oge case, where Judge Jordan found that the plaintiff was motivated and willing and had even made steps to try and find alternative employment, Judge Carlos considered that the appellant had little academic intelligence and little motivation and concentration, evidenced by the fact that he failed to complete his apprenticeships previously. Another point on which we could distinguish the outcome in Oge is that the plaintiff in that case was in the fourth and final year of an apprenticeship at the point of his injury and was therefore seen to have great potential to earn more in future employment. Judge Carlos in this case has suggested in his reasons that Mr Reddington did not even commence any apprenticeship. All the facts suggest is that Mr Reddington merely intended to commence a pre-apprenticeship that he had enrolled in. Judge Carlos's reasoning, taking into account the medical evidence and Mr Reddington's personal traits, logically led him to the conclusion that the earning capacity offered to the applicant as a sales assistant enabled him to earn at least 60% of his pre-injury capacity and his but-for earning capacity. He formulates this by asking the question in his reasons, how can one apply the but-for test in favour of the applicant in these circumstances? This means that the trial judge has considered that the but-for test allows for the fact that the applicant's but-for earning capacity may be greater than his pre-injury earnings. However, in this case, Judge Carlos, having assessed the evidence and having the advantage of assessing the applicant's character in trial, has reasonably concluded that Mr Reddington's but-for earning capacity is unlikely to be greater than his pre-injury earning capacity of $800 per week. In the extract provided of Judge Carlos's reasonings, he cannot possibly have referred expressly to all the evidence put forward at trial, and nor is he required to. We respectfully submit that it was put in the Waverley Forklifts case that we've mentioned in our submission, that a judge's reasons don't have to set out every single piece of evidence. In light of this, we submit that Judge Carlos has sufficiently discharged his duty to provide adequate reasons for his determination, that the appellant has not met the 40% loss of earning capacity threshold, which I respectfully remind Your Honours is largely discretionary. And I reiterate, Your Honours, that unlike the comparison of pre- and post-injury earning capacity test, the test that Judge Carlos was obliged to apply was that of a broad brush value judgment, as my learned colleague stated, and that is exactly what led His Honour to determine that Mr Reddington was able to earn 60% of his pre-injury employment. So I'd now like to turn Your Honour's attention to our third submission. We submit that Judge Carlos did not err in finding that a sales assistant was a suitable employment option and that this was consistent with the medical evidence provided. We would firstly like to submit that, yes, it is ambiguous as to whether regard must be had to this strict test of suitable employment that's set out in section 325(2)(g) of the Act, given the appellant's age being less than 26 years. However, we also note that it was observed in the case of Oge, a case which also involved a plaintiff who was under the age of 26, where Judge Jordan accepted that the defendant's submission that close attention to the statutory definition of suitable employment was open, and commented that this exception allowed for a judge to engage in a broader approach value judgment of assessing the question of economic loss. And given that the counsel for the applicant have confined their submission to the narrow definition of suitable employment, we'll deal with this question also. So Section 3 of the Act defines suitable employment as employment in work for which the worker is currently suited. A determination of this definition allows a judge to have regard to the nature of the worker's incapacity, having regard to the medical information given, as well as the nature of the worker's pre-injury employment. We submit that a sales assistant is consistent with the reports of the medical examinations commissioned, and therefore the definition in Section 3.1. As I've previously submitted, Judge Carlos made a finding of a suitable employment option based on those identified in the vocational assessment. As Dr. Moo's evidence shows, Mr Reddington was able to move freely throughout his consultation and was capable of performing alternative duties as long as he avoided lifting in excess of 5 kilos and extreme movements of the lower back. As was stated in the case of Richter and Driscoll, the physical demands of a sales assistant are very light. This is also reflected in the fact that the vocational assessment made the finding that this would be also a suitable employment.
I think Richter, which both sides have referred to, say that the judge needs to actually analyse the duties inherent in a job against someone's physical capabilities and restrictions. What do you say about the extent, if any, that Judge Carlos has done that in this decision?
We submit that, given the very scant excerpt that we have been given of the judgment, we expect that we can imply from Judge Carlos's reasons that he has considered the duties of a sales assistant generally, and we would confine those to probably lifting under 5 kilos most of the time. If it was a piece of clothing or even a box of clothing, it's unlikely to be more than 5 kilos. And also, moving around a store, talking to customers, nothing that would really impinge on his physical abilities.
Is there an inherent problem with the reasoning in the sense that he says, the judge below says that he's of no academic prowess and yet he's able to do sales assistant work, and that might be able to be overcome by taking up a trade or working with his hands?
We'd submit that it's a very logical conclusion to come to that someone with little academic prowess could move into the sales assistant job. It's not a job that does require any certificates or training or any sort of tertiary education. So we submit that this is a logical, reasonable finding that Justice Carlos has made. So if I can respectfully submit, Your Honours, that, as I've already said, the role of sales assistant is not one that requires heavy lifting and doesn't require much movement. Also, having regard to Dr. Nutbean's medical report, which stated that Mr Reddington struggles to sit for long periods, we submit that this won't really affect Mr Reddington in the role of a sales assistant, as sales assistants are generally moving about the store and on their feet most of the time. We further submit that whilst Dr Moo opined that Mr Reddington did have issues with concentration, once again this wouldn't be an issue, as a sales assistant working a 4-hour shift does not usually require any arduous concentration skills. Further, a sales assistant can also be Further, a sales assistant can also be seen to be suitable employment, as it's consistent with Mr. Reddington's previous employment when he worked for part-time at Gillard's supermarkets at school. We thus submit that on the evidence and the facts before us, a sales assistant is a suitable role for Mr. Reddington. And finally, as an additional point, if I can direct your honours to the fifth submission, we submit that the applicant fails in discharging their onus to prove that their loss of earning capacity was permanent. And so I'd just like to address that question of permanency. According to section 325(1)(a) of the Act, the applicant must show that his injury is a permanent serious impairment. The case of Barwon Spinners tells us that the injury will be permanent if it will probably persist and there will be no significant improvement over time as the injury will not mend. That case also held that permanence is whether an injury will persist throughout the foreseeable future and not merely into the foreseeable future. So we submit that Dr. Moot found that the applicant's injury had stabilised and that upon completing a pain management program, his treatment would improve his strength and his flexibility.
Did Dr. Moot say that it would improve his strength and flexibility for certain, or was she speculating there?
So we respectfully submit that none of these medical opinions can be said to be certain, and we're not trying to give them any certainty. We're merely using it as an indication of how we can possibly expect his condition to go. And based on that medical diagnosis, we've only got two before us. Based on one of the two, she does appear to be optimistic about his chances of recovery based on this pain management program. And it would make sense that if he improves his flexibility and strength, that his condition should improve in time. So we submit that this evidence indicates that Mr. Reddington's injury is recoverable, progressing to the point of improvement and therefore merely persisting into but not through the foreseeable future.
I'm sorry, I think you heard my comments this morning, and I'm going to reiterate them again in relation to this matter. I have concerns about the radiology in this matter indicating this plaintiff has a very serious injury. And I have some concerns about whether we would consider when a submission on the basis that this isn't permanent or there's a long-term injury, which is how I'm interpreting your submission. What do you say to that?
We'd submit that we have had regard to the MRI evidence, and it does say that he has slipped a disc. However, it's also important to remember that the two doctors he's seen in the independent medical examination have seen him a year and a half later and are reporting that he has had some improvement, seeing as he's walking about the office freely. We'd also submit that the MRI is clearly a report of the injury as it was. There's no medical opinion that comes with that in terms of any prospect for recovery. And so we'd take the medical opinion of the examiners later to suggest that, based on their evidence, that he could improve in the future. And it's also reasonable to assume that those independent medical examiners would have had details of that MRI before them, and they would know of his condition. And so based on that evidence, they wouldn't have made their diagnosis as they did if they didn't think that was the case. A year and a half later, it's clear that Mr. Reddington has already made some improvement. And one further point that we just wanted to make, Dr. Nutbean also states that Mr. Reddington was able to undertake most daily activities and that he struggles to sit. And respectfully, Your Honours, we do not find that there are times when we all struggle to sit for longer periods of time. We don't really find that this indicates any serious injury that he can't recover from. If this is the worst consequence of Mr. Reddington's injuries after one short year, then what's to say that he won't continue to improve?
I would submit that that's actually a pretty serious consequence. Struggling to be able to sit for longer than short periods of time. I appreciate what you're saying, but that to me is actually quite a serious consequence.
I'd respectfully agree with you, Your Honour, but we'd also put forward that this is just one in a few doctors' opinions that we have, and we can't really give more weight to one than the other. So if you have no further questions, I'll conclude my submission there. Thank you, Your Honours.
Thank you. Now we have Mr. Willis again. Thank you.
Your Honour, just a few quick points of rebuttal. First of all, just on the significance of the but-for test and the evaluative judgment raised by my learned friends, we suggest that based on the facts, Mr Reddington, prior to injury, was capable of earning up to $800, and then post that he has lost this. We do submit that his income wasn't likely to increase dramatically prior to the injury, but nevertheless, all his prospects of earning post-injury are beneath $800. And we submit that the trial judge should have found this in his reasoning when he states that Mr.
Why do you say they were likely to increase?
Sorry, Your Honour.
Why do you say his earnings were likely to increase?
No, we are accepting that his earnings, had the injury not occurred, were not likely to increase.
You're accepting that, okay.
Yes, we're accepting that. But we submit that nevertheless, his earnings post-injury are not going to be 60% of $800. And I'd just like to point the trial judge's findings that he said he could overcome educational deficiencies with his manual prowess. He's lost this manual capacity, and so therefore he cannot overcome the educational deficiencies, which is the position he's in at the moment. Secondly, to the Retail Industry Award, we submit that as a status of delegated legislation, it is not required to be tendered into evidence. But first of all, we submit that our learned friends erred in applying a casual rate. First of all, Justice Carlos didn't specify in his reasons that Mr Reddington would work as a casual sales assistant. He gave a broad approach. If Justice Carlos found that he could have earned that amount as a casual sales assistant, it was his job to specify, and he didn't, and so this court must assume that he adopted the broad approach. And furthermore, just the nature of casual work is that the employer has no obligation to provide ongoing work, and as it is inherently insecure, we submit that that type of work cannot ground a capacity to earn up to 60% of prior earnings. Lastly, just on the reasons point, our learned friends mentioned that because he'd referred to the vocational assessment and other matters, he had considered them, but we submit that mere referring to types of evidence is not sufficient. What is needed is a weighing up of considerations to discern a logical path of reasoning, and this was found out in Harris and DJD Earthmoving, and I'll now conclude. Thank you.
Thank you. We think that the best team in terms of the submissions was the respondent. They had a very tough case to meet because the decision below was so defective, but they managed to defend that decision as best they could in the circumstances. And probably the thing which tipped them over the line was the decision, reference to an authority that discussed how these under 26 provisions work in real life, being OGE, and comparing that to what the judge did in this case. So very narrow, but that's what tipped the respondent over the line. So I think that means that the winner of the competition is the respondent, but we thought both teams were excellent. I think clap. Yeah.